Perfect. Thank you so much for the invitation, Anna and Jarek. It really is good to be back in person to a conference. I just tried to think back, when was it the last time that I was giving a speech at an academic conference, and it was 2 years ago. We were fortunate in Vienna to resume in-person teaching for a while, but then usually after a few weeks we had to go back to online teaching. And the last real academic conference I attended was an arbitration conference at NYU Law School in March 2020. And I'm continuing in a way now, 2 years later. So let's hope that we are back to more of these interactions. I'm happy that so many people are joining via Zoom, and I'm very much looking forward to engaging both with you here in the audience and have some time left for questions and answers. The topic that I'm addressing, as mentioned, is the extent to which there is review of arbitration outcomes, of arbitration procedures. And I presume you've also discussed this very interesting chart that Jarek leaked to me about the internal, external mechanisms of review, which in a way is a little bit counterintuitive, because normally when we talk about arbitration, whatever form of arbitration, we think of it as a fast, single-tier form of dispute settlement without the intricacies of these endless appeals and other forms of review that we have before domestic courts in first line. One could even say that the lack of appeal mechanisms, allow me the cheap pun, is one of the most appealing features of arbitration, because it is something that has to be fast. And of course, I'm sure you talked about the kind of historic roots of mostly commercial arbitration being the law of merchants. And if we accept this kind of mercantile premise that time is money, then also settling disputes is something which is very, very important. Also, and I'm sure you have come across examples here as well, the idea that arbitration is always speedy is not always fully correct. We have witnessed in different forms of arbitration, and in particular in investment arbitration, which is my area of expertise, that this has grown more into a court-like proceedings. Some commentators have pointed to the influence of various common law techniques like extensive document production requests, evidentiary hearings, bifurcation, trifurcation, making sometimes arbitration quite an exercise, also time-wise. But in spite of all this, the fact that there is so limited review or appeal means that we are still have a time-saving component by the single-tier form of dispute settlement. I'll revert to that in a moment. When we say it's a single-tier form of dispute settlement, we have to acknowledge that even today there are certain forms of limited review, mostly in the form of set-aside or annulment proceedings before domestic courts, or in one form of investment arbitration under the ICSID Convention, the special proceedings before ad hoc committees in the form of annulment review. But leaving that aside, or rather reverting to that, at the outset, also very important, we probably have to distinguish now between different forms of review. So far, I have rather loosely used both review and appeal without going into differentiations here. On the one hand, we have mechanisms that aim at securing the fairness of the arbitral proceedings. And that is what mostly is domestic court set-aside annulment, exit annulment proceedings. And we have to distinguish this with other mechanisms that aim at securing the, and I use quotation marks, which I can only announce because I'm speaking, aiming at the correctness and consistency of outcomes. And of course, we will immediately recognize this is something that is more akin to domestic court appellate stages here. Let me start with the second one for particular reasons. Those who have followed the current debate of reforming investor-state dispute settlement, as it's particularly discussed in the framework of Working Group 3 of UNCITRAL, the UN Commission on International Trade Law. There, the lack of appeal mechanisms is arguably one of the main reasons why the correctness and consistency of the outcomes of investment arbitration pose a serious problem. Now, the current system of ad hoc arbitration without any doctrine of precedent is said to have led to inconsistent and arguably incorrect outcomes. Let's take a closer look at those two main points of criticism in regard to investment arbitration. My favorite one, correctness, incorrectness. In my view, the assertion that the outcomes of investment arbitration, and here we could extrapolate and say arbitration in general, may lead to incorrect outcomes, needs some critical review in itself. What can be considered correct or incorrect is something I would suggest highly questionable for lawyers. Lawyers normally agree that disagreement about the interpretation and application of the law is something which is intrinsic in law, and that there are hardly any correct or wrong decisions. Now, in most legal systems, we have accepted that there is a fiction of legal correctness in the sense that there may be final decisions by a final arbiter, normally a Supreme Court, that settles disputes and that must be accepted as the last word, rather the last written, not spoken word, that has to be accepted as the law as it is right now. On the other hand, that's exactly where we lawyers as scholars start to think about it. Because even if there is a final decision, we will debate to what extent this final Supreme Court or whatever judgment should be approved of, should be changed. It leads to follow-up questions. Now, if we accept that just because there is an appellate structure that leads to a final decision is not necessarily the correct one, in judicial dispute settlement, I would submit that also applies to arbitration. Also, arbitral outcomes are not correct or incorrect. They may be more or less welcome to the parties involved. They may be more or less persuasive, but they are not right or wrong as such. And therefore, this perceived correctness or incorrectness of arbitral awards is not really an issue that can be remedied by a review mechanism. After all, even at the appellate stage, if one is introduced, we may question the outcome finally. Why is not the lower instance the one that has correctly decided is. Where's a guarantee? Which one is the correct one? So let's assume we are happy for a final decision to settle it, but not necessarily seeking a correct one. If we are turning, however, to this second aim, the consistency of outcome, then of course, any form of substantive review mechanisms may indeed serve a very important purpose of predictability, consistency, coherence of outcomes, and some wish, some aim and purpose where an appellate mechanism in whatever form may be an adequate response. Now, that is something that we find in domestic court systems, usually, where there is a single Supreme Court or the like instance that will settle legal issues, that will develop an established jurisprudence in the various domestic legal systems. And I'm not a comparative law expert, but from my faint general overview of different systems, I would even pose that here, whether it's a common law type of stare decisis, doctrine of precedent, whether it's a civil law idea of jurisprudence constante, it's very similar that ultimately lower courts will be guided either because they are obliged to follow precedent or because they don't want to be overruled. So there is this function of actually developing more consistent outcomes. On the other hand, we should not overestimate the potential of domestic courts. Some of you may be from jurisdictions where Supreme Courts don't exist of, I don't know, an even number of 9 judges, but even of 50 judges. Large Supreme Courts exist in many countries, with the consequence that even within Supreme Courts, we have to form chambers, senates, however you may call them. And the phenomenon that we occur, or that we can witness there, is that there may be different lines of jurisprudence depending which senate you end up with on the final level of appeal. So consistency is certainly something that we may hope for, but not always necessarily get by introducing an appellate structure here. If we compare now what's happening on the international level, and I'm aware it's a bit difficult to talk about international dispute settlement because investment arbitration is this kind of hybrid thing. Not quite commercial arbitration, not quite classic interstate dispute settlement. It has something of both. But on the international level, up until recently, and in my age, recently means 20, 30 years ago, up until recently, there was only single-tier dispute settlement, from the International Court of Justice to the few other permanent forms of adjudication and arbitration we had. With international criminal law, ICC most prominently, but also the ad hoc tribunals, appellate mechanisms became very prominent. But here, the reason is a different one. I don't think it's primarily coherence that was in the mind of those who designed those tribunal statutes, but rather the specific rights of accused as they are enshrined in human rights provisions as a right to appeal a judgment, a criminal verdict. That led to the institution of appeals instances in the international criminal courts and tribunals. The idea of creating more consistency and coherence was first very prominently relied upon when the appellate body of the WTO was set up. If you look at the dispute settlement understanding, the kind of statute regulating what the dispute settlement mechanism should provide for, then very clearly consistent, predictable outcomes was one of the main purposes. Now, you may have followed, or those who have followed WTO dispute settlement, that there's still a debate about judicial activism, about correct outcomes. Maybe some unhappy member states just thought that the outcomes are often not correct, and that's why we don't want to appoint members to the appellate body. I don't know. But clearly, there are still debates about what can be achieved by the outcome. What can be achieved, however, is more coherence. If you have not ad hoc panels for each individual trade dispute, but if you have 7 individuals who will sit in chambers of 3, hopefully they will talk to each other, the likelihood exists that outcomes may not necessarily be fully correct, but coherent. And that is maybe something, and that's also in the debate in UNCITRAL and other places, whether that should be used for investment arbitration or can be used for other forms of arbitration, something which is very important. Now, let's leave the issue of substantive control of appeals aside for a moment and look at the other purpose of review mechanisms concerning arbitration. And that is reviewing not the outcome, but reviewing rather the procedure, the question whether the arbitration procedure by which an outcome has been produced was compliant with notions of fair trial, due process, and the like. Now, here, very interesting, we have already some experience. This is something which is not totally new. The possibility that the procedural propriety of the arbitral process is scrutinized, we find as a rule of law requirement. We also probably can see that it might be a requirement of constitutional law. I'll come back to that, as well as fundamental rights law. So it may have both a domestic reason why it's necessary, as well as an international reason why we need this kind of procedural review. When I say that it is on a more theoretical level, something that's required by the rule of law, I'm aware that we could go on for quite some time debating what concept of the rule of law we are using, what we are relying upon, what we mean when we talk about the rule of law. I've been chairing a committee of the International Law Association on the rule of law and international investment law. And I think we spent 4 years with the definition of the rule of law. I'm not sure whether we still have some room of debating. We probably do have. But one of the kind of common notion that many of my colleagues and I have been able to agree upon was, let's not focus on the Venice Commission notion of rule of law, the very European-centered notion, or too regional or too national concepts. Let's try to find something or to base our concept on something more widely shared. That, of course, means let's see whether the UN finds something. And indeed, there are a number of definitions of the rule of law. There's a very influential report by the Secretary General of 2004 on rule of law in transitional justice, which seems to be very focused and limited. But if you look at the notions, it's really something very broad in regard to the rule of law demands from states and all states. And the content of this definition is reflected because one may say it's just a Secretary General report. The content of this report is reflected in various General Assembly resolutions that have been adopted by consensus. So at least you don't have states vehemently opposing notions of the rule of law, which include, that's important for our purposes, procedural aspects like equality before the law, fairness in the application of the law, avoidance of arbitrariness, transparency, independent and impartial adjudication. So that's elements that we can work with when we say what may be required by arbitration. But before we do that, let me take some time in regard to the proposition that some form of review of arbitration may be required by national constitutional law or fundamental rights law. Let me start with constitutional, the constitutional compatibility, as it's sometimes formulated by our colleagues from constitutional law. How is it possible that we have arbitration when we have in most or in many constitutions a kind of exclusive power of the state to adjudicate disputes? Depending on different constitutions in the world, but normally the idea is we don't want to have any private courts. This is a state function. It's one of the core state functions. In most, I haven't made a proper analysis, I'm just suggesting in most constitutional legal systems, it seems that for historic reasons, but also because of the acceptance of quite some party autonomy, and although adjudication is conceived as a kind of exclusive state task, arbitration is still permitted as a privatized adjudication under a very important condition. Under the condition that such arbitration is performed in accordance with minimum requirements of the rule of law. That's kind of the conditionality, if you wish, under a perspective of constitutional law, which then means we need some checks and balances, whether these minimum requirements of the rule of law are complied with by private dispute settlement, and their national courts, the ordinary dispute settlement mechanisms under constitutional law thinking normally, they hold in reserve some form of review power and they control it, they recognize or enforce or de-recognize or refuse to enforce the outcome of arbitral tribunals. And very similar parallel reasoning we find from a fundamental rights, human rights perspective. Many human rights instruments, you're very much aware, certainly, contain something like a fair trial guarantee, mostly linked to any form of private law disputes, sometimes even broader disputes. So there should be a fair hearing before an independent and impartial tribunal, whether it's the Universal Declaration of Human Rights, the ICCPR, various regional human rights agreements. And permit me now to just focus on the European tradition. Strasbourg is the closest human rights court. That's why I thought it's maybe is easiest. The Strasbourg court has repeatedly held that Article 6, which contains the right to a fair trial, as well as to access to court, I quote, does not preclude the setting up of arbitration tribunals in order to settle disputes between private entities. So the Human Rights Court in Strasbourg generally accepts that agreements to arbitrate can be viewed as something like a lawful waiver of the right in Article 6 that guarantees a fair trial before a domestic court, as long as this waiver is voluntary, unambiguous, and not only the waiver, but also the procedure conforms largely to at least the core elements of a fair trial. So for some of you, this may sound familiar to cases about immunity, where if you grant immunity, then there has to be an alternative mechanism with largely similar adequate guarantees. Now, member states, in turn, member states of the Council of Europe, the contracting parties to the European Convention on Human Rights that have to guarantee the right of access, if they allow arbitration, then have to maintain a system of control that scrutinizes whether the arbitration process complies with minimum standards of the rule of law. So a certain level of scrutiny by the states of the procedure before arbitration tribunals can be viewed as an obligation under the European Convention of Human Rights, and probably also other regional instruments. I think these are very important policy reasons why some form of review must exist. And that also leads us to a short analysis, a short look of the status quo. And of course, we can ask, is review of arbitration really something new? And the short answer would be no, it isn't, at least to that extent. The arbitration process is considered to be a single-tier dispute settlement alternative to adjudication, but it is embedded in this broader context. And the broader context means a limited review, normally by domestic courts. By domestic courts in the form of an external review mechanism, we have that, and I'm sure you have discussed the Untitled Model Law, where we have certain set-aside annulment grounds. We have some forms of internal scrutiny mechanism in the ICSID Convention, where the annulment committee performs similar tasks. And that's what I want to briefly dwell upon now. When we look at the Untitled Model Law, the grounds for setting aside an award by a domestic court include traditional ones like incapacity of a party to agree to arbitration, the invalidity of the arbitration agreement, excess of powers if the decision goes beyond the arbitration agreement, but, and there we get closer to what we have just seen from a human rights perspective, an improperly constituted tribunal, the question of challenges of impartiality, independence of arbitrators, as well as, I quote from the model law, arbitral procedure not in accordance with the agreement of the parties, and if the party making the application was not given proper notice of the appointment of an arbitrator or of the proceedings, or was otherwise, most important comes at the end, otherwise unable to present his or her case. So there we are at the core of the procedural fairness. Of course, you know that this is largely modeled after Article 5 of the New York Convention, where it serves a similar purpose, the purpose of non-recognition or non-enforcement of an award. But in substance, it's a parallel, similar kind of review scrutiny. The equality of arms has been the core requirement when it comes to testing whether arbitral proceedings should withstand annulment, set aside, should be enforced or not. And we have a vast practice in this regard by national courts. When we look a little bit more closer at the ICSID Convention in investment arbitration, where this kind of scrutiny is intentionally excluded, it's not possible, shouldn't be possible, at least according to the prevailing view when interpreting the ICSID Convention, that a national court sets aside an ICSID award. And in order to compensate for that, the ICSID Convention itself has a mechanism of reviewing, limited review of ICSID awards. And the reasons, not very surprising, a tribunal was not properly constituted, it manifestly exceeded its powers, corruption on the part of a member of the tribunal, and most important for our purposes, serious departure from a fundamental rule of procedure or a failure to state reasons. But a serious departure from a fundamental rule of procedure is probably the core of the kind of review of the appropriateness of the arbitral proceedings that has been most prominent in the jurisprudence of various ICSID ad hoc committees. At the same time, these ad hoc committees have been very explicit in saying that their review power is limited, I quote, to ensure the fundamental justice of the arbitral process. And it does not permit them to serve as a court of appeal from the tribunal. So we very nicely find reflected the distinction that I proposed earlier on. As one committee put it, it's no part of the committee's function to review the decision itself, still less to substitute its own views for those of the tribunal, but merely to pass judgment on whether the manner in which the tribunal carried out its functions met the requirements of the ICSID Convention. So it's the legitimacy of the process by which an award was rendered, but not the correctness. What a coincidence that they said not the correctness. Now, I was quoting from MCI Power, and this is established jurisprudence, if you wish, by ad hoc committees. Now, what are the fundamental rules of procedure identified by ICSID committees? They include the right to be heard, the fair and equitable treatment of the parties, the proper allocation of the burden of proof, and the absence of bias. And other tribunals have characterized it in the following way: fundamental principles of due process, the right to be heard, the principle of equal treatment of the parties, independence and impartiality of the tribunals. So it's not just the procedure, but also the composition. But thereby, we see also the parallel to what human rights demands actually contain. It's a fair trial, and it's a fair trial by an independent and impartial tribunal. So we have very interesting parallels, whether you are a constitutional lawyer, a human rights lawyer, or whether you specialize in arbitral proceedings. Thus, arbitration as an isolated single-tier procedure without any form of external or internal scrutiny certainly is an exaggeration. We do have already review mechanisms, but so far they are limited. And I think that leads us to the core question, whether we need more review and whether we need additional forms of review. And here I think I discarded correctness already. What is left is consistency. Do we need more review in order to serve the purpose of more consistent outcomes? Now, one may question whether consistency is required and should be increased. And even if one accepts that we need more consistency, one may question whether different forms of review are adequate in order to reach this goal. Let me briefly address both issues. Do we need consistency? In my view, relative simple answer, yes, we need consistency. We've seen, not just because it's one of the rules of law, just the rule of law should be one of the most important things that we lawyers are serving. So of course, this is a very important notion, consistency and predictability as a rule of law requirement. But I think also for any kind of dispute settlement, in order to be successful in the sense of being actually used, creating confidence by users, they will lose confidence if they cannot, at least largely and broadly, predict the outcome. So consistency and predictability is something, even for the pure self-interest of survival, arbitrators like judges should internalize. Otherwise, they would not be asked to settle disputes. Now, if we accept that consistency is required, then the question arises, what kind of review is an adequate tool? What other kind of procedural necessities do arise in order to serve the purpose of consistency? One, and you're expecting me now to turn to appeals, I know, but let me pause here a little bit. One thing that's important and that one shouldn't underestimate is some transparency of outcomes. If we don't know what arbitrators decide, if arbitral outcomes remain confidential, you cannot create a predictable body of case law, quote case law, of jurisprudence. So that certainly is a kind of technical requirement that we know the outcome of the arbitral process. In investment arbitration, there has been a quite remarkable shift in the last 20 years from the kind of commercial arbitration paradigm of confidentiality towards more transparency. And I'm saying towards more transparency, and people can only speculate how many percent of investment awards are really out there and are public, because we don't know how many are not and are still confidential. But movements within UNCITRAL, the UNCITRAL rules on transparency in investment arbitration, the Mauritius Convention, they show a certain commitment and drive towards more transparency. And it's because of that transparency also that we have become aware of inconsistent outcomes. Otherwise, we don't even know that maybe some tribunals follow the Maffesini interpretation of MFN clauses or don't, and others follow a broad approach to umbrella clauses, whereas others disagree, and that some tribunals think that a state of necessity is the same under Article 25 of the Articles on State Responsibility or under a specific emergency clause. So there are lots of fields, and we could endlessly debate whether there is too much inconsistency or whether there is relatively high degree of consistency apart from this. There is inconsistency. I think that is uncontroversial. And now the question, of course, arises, how is this current state of partially inconsistent outcomes going to disappear? One approach is to say, well, we have transparency and we have to wait, kind of survival of the fittest. Maybe in 50 years, there is a kind of jurisprudence that will develop because it's the more plausible way to a legal problem and tribunals will generally follow it. That's not excluded, but we don't know. Maybe some form of substantive review, appellate review will accelerate that. So to introduce an appellate stage for investment arbitration, whether it's, and you may have followed, there are ideas about a multilateral investment court, a two-instance, fully fledged permanent court, or whether we combine arbitration with an investment appeals mechanism. That depends on the political will of the states that want or don't want to reform the system. But both of those would contribute to more predictability, more certainty. Let me also remind you that that's not totally new, what we're discussing in UNCITRAL right now. Almost 20 years ago, ICSID discussed whether there should be an appellate mechanism like in WTO, and there were certain papers and conferences devoted to this issue. It proved that amending the ICSID convention is almost as difficult as amending the UN Charter, so it's impossible de facto. And now this whole debate about appellate structures has moved to UNCITRAL as a multilateral forum, but it's also very strongly pushed by the European Union, and the European Union the Commission has been given a mandate to propose a multilateral investment court. We shouldn't forget, however, even such a multilateral investment court, the most radical form of introducing review to investor-state dispute settlement, may not fully guarantee coherence, predictability, uniformity of outcomes. That is something that is very obvious, but sometimes forgotten in the debate, because we still have numerous different international investment agreements which have to be applied. And although those thousands of BITs contain very similar standards, they're not identical. And there may be very important differences, and we cannot expect even a single court or an appeals mechanism to disregard those differences in the applicable law. So not only a substantive appeals-like review mechanism would be required in order to achieve full coherence and predictability, but also a uniform, single, coherent, multilateral investment agreement. But we know this is even further away currently in the future. Now, let me conclude, because I'm very much looking forward to your questions and comments, by two propositions. First, review of arbitral tribunals is not a new proposition. In a way, it's a matter of routine already for national courts, ad hoc committees under the ICSID system to review not only the composition of arbitral tribunals, the procedural fairness of arbitral proceedings, but so far we don't have any mechanisms in order to assess the quote correctness or consistency of outcomes. And while I would suggest that any corrections concerning, any discussion and suggestions concerning the correctness appear questionable, increasing the consistency of outcomes would certainly contribute to the rule of law goal of predictability, and that the introduction of some form of appellate review appears to be an adequate tool which can be introduced without necessarily compromising the advantage of efficiency of arbitration. Thank you very much.